Well, I've got about 2:01, so why don't we begin? Hi, everybody. Thanks for joining us today. I'm Dennis Kelleher, Better Markets co-founder, president, and CEO. This week, the crypto industry is holding what it calls a day of action on Capitol Hill, where they're going to lobby members of Congress to enact their special interest legislation, which would create very favorable regulatory environment for the crypto industry. But that would come at the expense of customer, investor, and financial stability protections, and it would also endanger our banking and financial systems as well as our economy. This so-called Day of Action is just the latest in a widespread, well-funded, years-long influence campaign by the crypto industry to get Washington to legalize and legitimize a predatory, lawless, and often criminal enterprise. Part of that is lobbying Congress and the executive branch. Part of it is a massive advertising campaign. Part of it is hundreds, if not thousands, of lawyers and lobbyists attacking the regulators at the SEC and other financial agencies. Sadly, part of it is many of those same people boosting their favorite regulator at the CFTC, who they hope and expect is going to go easy on them. And a key tactic in this information campaign is to create a smokescreen to obscure what they are really trying to get Washington to do and crypto's track record. And that starts with crypto not having a legitimate use case for the last 14 years of trying. Now, it has plenty of antisocial, illegal, and criminal uses. It's great for ripping off customers and investors, money laundering, tax evasion, ransomware. And this has been repeatedly proved by the bankruptcy of numerous crypto firms, the commingling of customer funds, if not their outright theft, misrepresentation, lies, and frauds, kind of best illustrated by the collapse of FTX and the arrest of its founder. But it wasn't only FTX. As you know, there's been arrests of a lot of other people, including the CEO of Celsius last week, hundreds of lawsuits filed by the SEC, dozens of lawsuits filed by the CFTC. And the crypto disinformation campaign and smokescreen are all designed to make people forget these compelling facts. And that's why we're here today. We want to talk about the facts, not a disinformation campaign. There are no paid spokespeople repeating the industry's talking points and spin. We're going to discuss how the industry is currently regulated, how it wants to be regulated. We'll consider how the regulators are doing or not doing their job, and the proposals to change the regulation of crypto, and maybe even a little bit about the current cases in the news and other activities. So there's a lot to cover. So let me introduce the panelists and get started. For those of you who don't know me, I co-founded Better Markets 13 years ago and have served as its CEO since then. Before that, I was privileged to hold several very senior positions on the staff of the United States Senate. And before that, I was a partner at the law firm of Skadden Arps, Slate, Maher, and Flom. Now, our first panelist, who we're very lucky to have, is Hillary Allen, who is a professor of law and associate dean for scholarship at the American University Washington College of Law. Hillary teaches banking law, securities regulation, and business association. She has written extensively about crypto regulation and risks and digital assets, including writing a very terrific book, which I'm going to shamelessly promote and hold up right here. You should get it. It's fantastic. She's also testified before congressional committees on these issues. A second panelist, who are also just very fortunate to have with us, is Dan Berkovitz. He has served in numerous top-level positions in the regulatory space, including as a CFTC commissioner, and prior to that, as the general counsel at the CFTC for 4 or so years. Most recently, he served as the general counsel at the SEC. He was also previously a renowned longtime staffer to the Senate Permanent Subcommittee on Investigation, known as PSI. Dan has also testified before Congress on the regulation of crypto and crypto markets, and has a deep understanding of the issues facing regulators in the Washington policy ecosystem. So welcome to both of you, and thanks very much for joining us and lending your expertise to what are kind of complicated and incredibly important issues. Without further ado, I wanted to start with you, Dan. The crypto industry and its advocates claim that they can't possibly comply with the existing laws and rules that, of course, comply to everybody else in the financial industry. Everybody else in the financial industry, from the small shops in your hometown all the way to the big Wall Street firms, figure out how to comply. But crypto says they need special rules and laws, and they claim there are regulatory gaps that have to get filled. How would you respond to that criticism or complaint?
Well, thank you, Dennis. It's a pleasure to be here with you today to try to provide some ground truth as to what the status of the regulatory system is. So there is a lot of talk, as you've mentioned, about the so-called regulatory gap. I'll start off with just the bottom line on the regulatory gap and then try to address some of the confusion out there. And I say confusion, quote unquote. I don't think it may be confusing to a layperson, but the law actually is pretty clear on the respective jurisdictions here. The regulatory gap really is a narrow area where neither the CFTC nor the SEC has jurisdiction over the trading of crypto assets. And it's not only crypto assets in this regard, it's commodities in general. And that specific regulatory gap is with respect to assets that are not securities and they're not derivatives. So if it's not a security and it's not a derivative, neither agency has jurisdiction or authority to prescribe how those assets should be traded. And this is really colloquially known as the cash or the spot market, referring it to, in simpler terms, the cash or spot market for digital assets. Bitcoin is an example of that. The CFTC, with respect to these assets, cash market, has authority to take enforcement action if there's fraud or manipulation in the market, but they don't have authority. Neither agency has authority to write prescriptive regulations and say you have to trade it on an exchange and how the intermediaries should be regulated. And the CFTC is the only agency right now on the cash market that could come in with post-event actions for fraud or manipulation. And this really isn't a unique gap, so to speak, to digital assets. Generally, we don't regulate the spot or cash markets. The CFTC, the CFTC, I'll start with them, has jurisdiction over commodity futures and other derivatives on commodities. The simplest way to think of the CFTC's jurisdiction is really in the name of the agency. It's the Commodities Futures Trading Commission. That word futures and trading commission is critical. It's not the Commodities Trading Commission. Generally, it's the Commodity Futures Trading Commission. Since Dodd-Frank, it's also has jurisdiction over the swaps market. So it's really a Commodities, Futures, Swaps, and Options Trading Commission, but it's not just if something is a commodity trading commission. So just being a commodity doesn't give the CFTC regulatory authority. On the other hand, we have the SEC, which has jurisdiction over securities. So securities go to the SEC, commodity futures or derivatives go to the CFTC. Now, for certain instruments, if it's both a commodity and a security, both agencies, a commodity derivative and a security, both agencies would have jurisdiction. So what would that be? Well, that goes really to the definition of a commodity. And people think of, when they think of the CFTC, as I say, maybe as a non-lawyer, you think of commodity, you think of something tangible, you think of gold, silver, wheat, whatever, something that's actually a good. But in the Commodity Exchange Act, the CEA defines a commodity in terms of, it lists a number of agricultural products. CFTC jurisdiction started in the ag markets, wheat, corn, oats, things like that. And then in 1974, the CFTC was given broad authority over anything that is the subject of a futures contract or may be in the future the subject of a futures contract. So what's a commodity and what's a future is somewhat intertwined. A commodity is really anything that you can have a futures contract. And that could be a security. There are futures on securities, Apple stock, IBM stock, or whatever. You can put a futures contract on that, and that becomes within the CFTC's jurisdiction as a futures contract. Now, for those security futures, the agencies share jurisdiction. So if it's a derivative, contract and it's a security, there's dual jurisdiction. If it's just a futures contract on a commodity, that's not a security, that's CFTC, and securities are SEC. So the jurisdictional lines between the CFTC and the SEC are actually quite clear. It's not this, is it a security or is it a commodity? The real question is it a derivative, like a futures contract or a swap, or is it a security? If it's a security, it goes to the SEC. If it's a future or a swap or an option on a commodity, it goes to the CFTC. If it's both an instrument that's both a future contract on a security, both agencies share jurisdiction. And this is, it may be confusing to a layperson who really is not familiar with the technical definition of what a commodity is or the CFTC's jurisdiction, but it's not a question of, is it a commodity or a security? It's a question of, is it a security? And then is it a derivative? And so the agency jurisdictions are fairly clear in this regard. And the gap is, if it's not, again, going back to what I said at the beginning, if it's not a security and it's not a derivative, it's just the cash market. Currently, the CFTC does not have regulatory authority. It's the Commodity Futures Trading Commission. But this is the situation with virtually all cash markets. We don't regulate generally the cash markets. We don't regulate just the wheat market or the gold market or the oil market out there. But in the case of cryptocurrencies, with the prominence of the exchange traded and the way these exchanges are operated right now without regulation, that regulatory gap is detrimental to investing public.
But I take it, though, that the gap is actually both quite common, which is to say spot market regulation of any type of commodity is currently, outside the purview of the regulators. And what is within the purview of the regulators falls within either the jurisdiction of the SEC or the CFTC. And if I understand you correctly, cryptos claim that they can't possibly comply with the laws, currently existing laws, as they apply to securities and derivatives or commodities. Their claim that they can't possibly comply, I take it your view is that that's just not correct.
Well, both the CFTC side on the SEC side have incorporated tremendous change in technology over the last 80 or 90 years, and all the various types of asset classes and that have come into being over in modern markets have successfully been integrated into the regulatory system. That's correct. The regulatory system can handle all types of assets and commodities, and I don't think it's unable to handle crypto assets either.
Great. Hillary, I'm going to ask you a question about your recent testimony before the House Financial Services Committee. Before I do that, I want to let our audience know that we will be posting, there's already on Better Markets website, bettermarkets.org, a variety of resources, including the testimony of Dan and Hillary and other reports and documents for background. We'll also be emailing those who registered for this webinar links to various documents, including Dan and Hillary's prior testimony and other things. Although you could go buy, we're not going to send you the book, you got to buy that yourself. But I did tell Hillary I was going to be shameless, and I didn't want to let her down about being shameless in promoting her book. Hillary, you testified before the House Financial Services Committee that, quote, it is entirely possible for blockchain-based technology business to comply with existing investor protection and financial stability regulation, close quote. The industry claims otherwise. Why do you have your view?
Well, I think something to be really careful of in all of this is to not confuse the technology and the economics. So the technology could be the foundation for all kinds of different businesses. The businesses that have grown up around this technology, however, have had to benefit, I think, from conflicts of interest to be profitable. So I think we have sort of this very credulous attitude sometimes to claims of technological superiority, solutionism, et cetera. And the problem with this blockchain technology is it's actually not great. If you actually talk to technologists, it's pretty inefficient. You might be willing to accept that inefficiency if it actually guaranteed decentralization, but it doesn't. It can provide technological decentralization, but it does nothing to remedy economic centralization. So you have a technology that's not ideal. And so because of that, it's not really generating, to my mind, profitable businesses. And most of the use cases that we've seen so far have been purely speculation. So if you want to profit from this technology, then you have to find a way to create a business model that does that. And unfortunately, the way the industry has structured their business models is that you see a lot of conflicts of interest. So, you'll see an exchange that also has a hedge fund attached, that can trade against its customers, that can also use customer funds and for betting. And so once you have all of those things wrapped up, you have a lot of potential harms to investors. And these are things that are not allowed by the securities laws, because we've learned from hundreds of, at least nearly 100 years or going back further of practice, that this is how investors get harmed. So I think there is some truth to the statement that the existing crypto business models are incompatible with existing regulation, but it's not the technology that's incompatible. It's the fact that to profit from this technology, generally speaking, businesses have done things which we wouldn't allow under the traditional securities regulation because of their propensity to harm.
So if I'm understanding you right, what you're saying is they can comply. The problem is that their business model is kind of at its core predatory, where it combines multiple activities. It would be like, I think I saw somebody say, it'd be like if JP Morgan Chase had a hedge fund, was a clearinghouse, was a custodian, and was an exchange all at the same time, and commingled customer assets and funds, while at the same time betting against them and front running them, which of course is not allowed. And in fact, that's why the securities laws after the Great Depression were put in place to eliminate the conflicts of interest. And I guess what I understand you're saying is that what crypto wants to do is take down the walls that protect customers in the financial system so that they can maximize profits. So it's not the technology that's driving it, it's their business choices as to maximizing profits and how they're structuring their business. Is that right?
Yeah, as I said, you've got to separate the technology and the economics. The technology is, perfectly legal technology, even though I think it's not great. You could use that as the basis for a business, but there has not been, no one's found a way to make a profitable business out of this without the more predatory practices, or at least, if not predatory, conflicted practices that are inherent to the industry.
I think you also referenced innovation, because that's all we hear is innovation, 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 as if it's motherhood and apple pie, and it only goes one way, which is greatness and goodness. And the industry has been nothing less than vicious in attacking the Biden administration, the policymakers and regulators. In fact, they're constantly got this huge campaign to attack Gary Gensler and demonize him. In this particular ad was pushing jobs out of America, and he's anti-innovation, destroying digital innovation and things like that. What are your thoughts on these claims of innovation? Is it real innovation that's productive and useful to the American people, or is it predatory innovation that's really just maximizing the profits of a few at the expense of the many?
So, I'm going to say the heretical thing and say that not all innovation is good. We have innovation in, refining fentanyl. That's not the kind of innovation that we consider to be a good thing. So I think, and I actually got an op-ed coming out in the Hill this week that looks at this issue. Innovation, the relationship between innovation, harm, and regulation is something that I think we need to have a real reckoning with. And I think it's really interesting if we look at the OceanGate submersible. If you look at I think everybody knows about this, but last month a submersible tragically imploded, killing all the passengers on board, including its developer. And its developer was quoted as saying all kinds of things that are reminiscent of the rhetoric that you've just talked about, Dennis. Rules get in the way of innovation. Innovation needs to take down the regulatory state. We need to take more risks, et cetera. And, that was just a very sort of strong encapsulation of the dangers in taking fealty to innovation too far. Now, of course, innovation in blockchain technology is not the same as innovation in submersibles, but that mindset about innovation at all costs is something that is really dangerous and can cause a lot of harm to the public. And it's precisely for that reason that we have regulators. We need innovators, but we also need bulwarks against innovation that harms the public. And that's the critical role that the SEC plays. And that is the role that, understandably from a profit perspective, people who want to profit from these innovations do not want regulators standing in their way. But the job of the regulators is to protect the public from the harm that could be occasioned.
It reminds me of people who continually brag about how fantastic the U.S. capital markets are. They're deep, they're broad, they're liquid. People from all over the world send their hard-earned money to invest in our markets. And I'm always reminded of the fact that what they forget to mention is one of the reasons people from all over the world send their money here is because they're well-regulated markets, and people actually believe that their money's not going to be stolen and ripped off by everybody and their brother, because they're not only well-regulated, but there's a cop on the beat. It's called the SEC and others. And those regulations and laws actually are what enable us to have, capital markets that are the envy of the world. And that gets me, Dan, I was going to ask you, and I think I still will ask you about, the Howie Test, because there's nobody in the world that doesn't want to talk about the Howie Test, right? And you've talked about how the law clearly applies to digital assets and the Howie Test. And so I was wondering if you could explain as much as possible in English why it is that the crypto industry's claims that most of these tokens and crypto activities are not security. They claim they're not securities and therefore are not regulated by the SEC. I think you have a different view, and maybe you could talk a little bit about that.
Well, you've mentioned correctly the linchpin here. The key test is the Howie Test. Now, the definition of a security in the securities laws, they're very similar in the statutes and the Security Exchange Act and the Securities Act, the other main regulatory acts of the SEC implements. The definition of a security is very, very, very similar for all intents and purposes, and they're the same. And it lists a whole variety of things: notes, stock, security futures, security-based swap, bonds, various certificates of interest. And one other element in that definition is investment contract. And in the digital asset space, what a lot of the debate boils down to, and the key test is, are these digital assets investment contracts? What's an investment contract was really laid forth in the key Supreme Court case, SEC versus Howie. It's a 1946 case. And it's been disparaged by a number of folks recently. Oh, this case applies to orange groves, and we can't possibly have a case that deals with orange groves applied to this new technology, digital assets, and the world has gone past orange groves. But really looking at what the Howie case said, it's not just about orange groves, and it's been applied to a whole variety of things. Howie involved a developer of a citrus grove who, what he sold was not just the crop, not just the oranges themselves, but how he would cultivate and market the crops. And the contracts that Howie entered into with investors provided the investors with not just the crops, but that Howie would market it and then pay the investors. The Supreme Court and Howie, interpreting the term in the securities laws, investment contract, declared in that case an investment contract as an investment of money in a common enterprise with an expectation of profit based solely on the efforts of others. And what this test really is, that's the four-part legal test. But what it really says is, if somebody comes to you and says, "Give me your money, and I'll make you wealthier, or I'll make that, I'll give you a return on that. If you give me your money, I'll give you a gain on your investment." That's the type of arrangement that the securities laws are attempting to or do address, and it's the protection of those investors. If something is an investment contract, if somebody's trying to get you to give them your money on a promise that they'll give you more money in the future, that's a security, and there's disclosures, and there's various, you have to be accurate in your disclosures. You have to tell the investors about who you are and your financing and what type of company you're operating. And this is really for the protection of investors. Okay, so people just don't go around promising that they'll make you wealthy. Howie is not just about orange groves. The Supreme Court in Howie said that the test is, quote, a flexible rather than a static principle, one that is capable of adaptation to meet the countless and variable schemes devised by those who seek the use of money of others on the promise of profits. And the test that I spoke about just a minute ago, whether it's an investment of money in a common enterprise with an expectation of profit based solely on the efforts of others, is a facts and circumstances test. The test is clear. There's no uncertainty about what the Howie test says or what an investment contract is, but it depends on the facts and circumstances. The test is clear. What the outcome is will depend on the facts and circumstances of the promises being made and the type of scheme that's involved. So the SEC has held a number of crypto assets to be securities as investment contracts. There's a number of pending enforcement cases on that. The SEC has been successful in a number of other cases that it's already brought. But the Howie test has withstood the test of time. It's applied to a whole variety of things consistent with the Supreme Court says it's countless and variable schemes devised by those who seek to use the money of others on the promise of profits. You talk about whiskey, cosmetics, chinchillas, cattle embryos, fruit trees, cryptocurrency, you name it, the Howie test could apply to it if somebody's trying to get your money and on the promise of making you wealthier.
Yeah, and of course, that was the whole point of the securities laws when they were passed, because leading to the Great Depression, the schemes were limitless and ripping everybody off, a lack of disclosure, rampant fraud, but no enforcement. And so the laws were written to be incredibly broad for that purpose. And the Supreme Court and Howie, obviously, following that trend, restated that. Now, some people not only have criticized the decision as being about oranges and not about securities and therefore not applicable, which is laughable on its face, but they also say, oh my gosh, it's so old. I mean, why should anybody follow a 70-plus-year-old case, which ignores, I think, the multiple times since then the Supreme Court has addressed it again, and innumerable courts across the country, I think. So I think the question is it really still legitimately valid, good law, Dan?
Well, I think absolutely. It's been the bedrock of securities law for a long time. There's many cases on it. The Supreme Court, as you mentioned, has essentially affirmed the approach several times. Most recently, it was actually in the Reeves case, which actually they were talking about notes in Reeves, but the language in Reeves, the court said, let me just read it for a second here. In defining the scope of the market it wished to regulate, Congress painted with a broad brush. It recognized the virtually limitless scope of human ingenuity, especially in the creation of, quote, countless and variable schemes devised by those who seek the use of the money of others on the promise of profits. So it quoted Howie as recently as 1990 in talking about the breadth of this, and that is really the utility and the essence of Howie. It's not a case about per se oranges. It's a case about schemes using the money of others on the promise of profits. Congress clearly wanted the securities laws to be broad. The Supreme Court, the appellate courts have consistently interpreted it that way since the securities laws were passed, and it's worked. Dennis, you mentioned the strength of our capital markets and why money comes to this country. This scheme that Congress set up, maybe I shouldn't use the word scheme, because of what Congress set up, this structure that Congress set up in the 30s has been tremendously successful in powering generations of wealth creation. And the breadth of the Howie test and the scope of it and the fact that the securities laws encompass all these types of schemes virtually to this day, without exception, virtually really is the strength of our system. So I think Howie is extremely good law, and it's withstood the test of time in its application and its utility.
And that, of course, brings us to really one of the most recent developments in crypto, which is the district court decision last Friday in the Ripple case, which everybody wants to get people's thoughts on. I can't tell you how many questions I've got from people saying, can you explain this to me? As I understand the decision, the court ruled that sophisticated investors get the protection of the customer protection laws under the securities laws because they're sophisticated, they're smart, and they read everything. But retail investors, they're kind of dumb. They don't read much, and they don't believe what the company's saying anyway, so they don't get protected by the law, which most people seem to be taking away as the thrust of the decision, colloquially anyway. So Hillary, let me start with you. What are your thoughts on the Ripple case? And then Dan, we'll go to you after Hillary tells us what she's thinking.
Sure. So, I mean, I think your colloquial take on it was my reaction as well. So, I mean, first of all, I think, it's important to contextualize this. And, as Dan has already mentioned, there have been many court decisions where I think the SEC had an almost unbroken streak of courts agreeing with its analysis that crypto tokens satisfied the definition of an investment contract per the Howie Test. And in fact, in the Ripple decision that we got last week, the judge also found that in some circumstances, the XRP tokens issued by Ripple were securities. And that's what you're referring to when you're saying that the institutional investors got the protections, because the judge found that in the sales of the tokens to institutional investors, there was in fact an investment contract, therefore the securities laws and all their protections applied. It does seem, for someone who is a securities, professor, it just seems very counterintuitive that the court or the judge would then go on to say, but the retail investors who purchased in a different way, that they are the ones who aren't protected. And I think there is something really important to take away from this, which is this is not just a precedent about crypto. Right? This is a precedent about investment contracts per se. And so, as we see people taking victory laps about this conclusion that in some contexts, these tokens are not securities, I think it's really important to remain mindful of the fact that this means that other types of securities will also potentially not be considered or securities and not give protections to retail investors. And so I think this really, to echo the point that both you and Dan have made, our capital markets are robust because they are well regulated. And all this decision, as well as, and I'm sure we'll get to this later, a lot of the the legislative proposals that we see on crypto, a lot of them in trying to create a new regulatory structure for crypto are actually decimating the securities laws writ large. And I think it's really important we keep that in mind as we go forward, because what will these things do to our capital markets generally? How will investors be exposed generally? This isn't just about crypto anymore with all these changes being proposed and made to the securities laws.
Yeah, actually, one of our audience questions was the decision would seem to threaten broader financial regulation. For example, anybody could claim they're selling securities. They are not selling securities to retail investors if they just put it on the blockchain, and they only have to worry about sophisticated investors. Dan, what are your thoughts on Ripple?
Well, Dennis, I hate to say it, but I mean, I think you portray it even perhaps in too positive a light, because I don't think even
really have I been accused of that, Dan?
I don't think even the sophisticated investors get anything out of this, because frankly, the court ruled that yes, these transactions were investment contracts, but to the extent they're institutional investors, what will happen in the future as a result of this is they say, okay, they're securities, but they're exempt from registration because they're accredited investors. So you'd get basically distributions to accredited, sophisticated investors without registration. They take advantage of a registration exemption to distribute it, and then they turn around and put it on an exchange to the public. So, I mean, I'm trying to, you know, the potential, I don't want to say that this decision will do this, but there may be a number of arguments and follow-on arguments as a result of this case that could lead to that result, depending on how the follow-on cases go, where you essentially have an initial exempt distribution to institutional investors, to other sophisticated insiders, and then they turn around and put it on the exchange to the public. And with a exemption for registration, you wouldn't get any, virtually no public disclosure, but you'd have a public market. So I don't think this case goes that far and enables that, but if you start thinking about the arguments that people are going to make based on this case, that exchange trading, that these secondary distributions, well, on an exchange, who knows? You don't know who you're giving your money to. You don't know that when you trade on an exchange that the money's an investment in a common enterprise. It's all anonymous. I think people might start taking language from this and arguing in subsequent cases that secondary markets are not investment contracts. And really, you know, the other way to look at it is that the whole thing is a scheme, that rather than look at each element of this as a contract individually, look at the whole thing being an investment scheme. I just, anyway, so I think the implications of this are yet to be fully seen in some of the subsequent cases. Whether this case goes on appeal or not, I don't know, but there are all sorts of implications of the reasoning in here. There is footnote 16, which says, I'm not saying that the secondary markets are investment contracts. So I think there's a lot of uncertainty as to what the final, you know, what this means. And there's going to be more litigation basically over some of the language in here.
Is it fair to say that you both think that the crypto industry and its allies cheerleading this decision is ushering in a devastating defeat for the SEC and a resounding victory for the industry is a tad overstated? Yes?
Yes.
All right. Well, I know everybody wants to talk about Ripple. I'm not really sure there's much more to say on that. I was going to switch subjects given the time, but just want to make sure there's nothing else either one of you want to add on Ripple. Okay, so you know, Hillary, proponents have made promises that crypto is going to revolutionize money or payments or finance or all of the above. And the promises remain unfulfilled and look increasingly unfulfillable. But a lot of policymakers seem to have accepted them at face value, supporting crypto experimentation as, you know, a necessary step towards some vague, innovative future. And interestingly, we had a question from an audience, somebody in the audience. It's somewhat related, which is cryptocurrencies pretend to be independent of fiat currencies, but would be worthless if not convertible to fiat. And then I love this question. I have to think about this phraseology. As such, they are like vampires, which feed on the legal enforcement of real money. You know, if contracts specified in crypto only have value if enforced by the legal system of the state, how can it pretend to be independent of it? So I know that's a lot, but what do you think?
Well, when you spoke of that vampire analogy, it made me think of stable coins, right? Which is, you know, you have an entire system, the crypto ecosystem, that was so volatile that it, you know, basically impeded transactions. So they had to come up with something more quote unquote stable. And where do stable coins get their stability? From investing in, you know, government securities. You know, and so they're sort of vampires of in that respect. But yeah, I mean, I think, you know, the thing about crypto that it does very well is that it diagnoses pain points in our existing financial system, right? It's true that payments in the United States are too slow. It's true that we have a lot of people who are unbanked and have no access to financial services other than check cashing, et cetera, and payday lending. That's a problem too. And so I think the diagnosis of the problems is often spot on. Problem is crypto doesn't have any solutions. It, you know, basically perpetuates and sometimes exacerbates the existing problems. But, you know, the diagnosis of the problems and the story that you can tell about them is very compelling because they are in fact real problems. And I think sort of a lot of policymakers, you know, hear this diagnosis of the problems, and it's very tempting to believe the fact that technology can fix this, right? It's very tempting to say, well, all we need to do is program a few things and this magical technology will make all those problems go away without you having to do the hard work in Congress of getting laws passed, et cetera. It's very appealing, but it's not realistic. Technology isn't magic, right? I mean, as I said, getting back to we've got to separate the technology from the economics, right? The economic forces will continue to persist even if they're using new technology. So, I mean, for example, we hear that crypto can bank the unbanked. As the questioner you quoted mentioned, right? People don't get paid in crypto. People can't buy a loaf of bread in crypto. So crypto only works if you can convert into and out of fiat currency. And how do you do that? You do that through an exchange, a crypto exchange. And what do crypto exchanges require before they allow you to transact on them? A bank account, right? So to say that this can bank the unbanked is just frankly patently it's ridiculous. We hear promises that this is going to decentralize economic control. And again, these are nice promises to hear. I mean, coming out of 2008, the banks did perform terribly. Wouldn't it be nice if we could have a world where we didn't have to rely on the big banks? I'm sympathetic to the appeal, but what we see in crypto is technological decentralization. But as I said before, then you have economic centralization that is often worse than what you see in the traditional financial system. And the intermediaries that have that economic control are not regulated, and they behave worse than the traditional financial system as a result. So, I mean, I think, as I said, just take everything you hear from the industry with a grain of salt. One of the challenges in this space is that it is complicated to get up to speed on, because you have to understand both the finance and the technology. And those are two skill sets that don't often come together. And so because so few people have those skill sets, the ones that have them are usually in the industry. And so it's hard to get independent research or discussion of these issues from people who understand it. And so I'm very sympathetic to the dilemma that policymakers have in trying to inform themselves about these issues, but you do need to take what you hear from the industry with a grain of salt, because their job is to maximize their profits.
Right. And the problem is they're adding ambiguity to complexity, and it's the industry's interest to make sure it continues to be complex and difficult to understand. I do want to mention for the audience, and I think Madeline put it in the chat, Better Markets actually put out a fact sheet on stable coins, which you mentioned, which we refer to as unstable coins. I suggested to a member of Congress that maybe they would think of truth and labeling and label their bill unstable coins. That wasn't well received. Weird. Dan, I don't know if you have any thoughts on how crypto claims to revolutionize money or payments or finance. But if you do, let me know. Otherwise, I'll jump along. And I don't know if either one of you want to comment on this. There's a lot being said. Also, not only are they going to revolutionize payments and finance, and not only are they going to be banking all the unbanked, because there's just going to be the magic wand that makes all these things go away. It's also great for communities of color and underserved communities. This cornucopia of financial services will open up. But all the literature and data I've seen has actually shown that the industry, at least parts of it, target marginalized communities and frankly just rip them off quite extensively. And there was Brookings has put out a very extensive piece on this. The Atlantic had a very long article on this. Everything I've seen. I don't know if you have any thoughts on that, Hillary or Dan.
I can jump in unless Dan, you want to go?
Well, I would just add, as a former regulator, or when I was in at least at the CFTC and on the commission, the charge of the CFTC, one of the purposes of the CFTC, is to promote responsible innovation. I mean, there's innovation in our markets. There needs to be innovation to help. We are talking about our capital formation markets and our risk management markets at the CFTC, and innovation has been one of the reasons why we have such a robust and world-leading markets and so on. But I would emphasize it has to be responsible innovation, and there's no reason that innovation per se can't be compliant with the regulatory system. And compliant innovation is what makes the system strong. So again, I would just stress responsible innovation.
So, well, let me just jump in before I get to you, Hillary, on that question. Dan, somebody in the audience actually raised this very question about the CFTC's statutory obligation to promote innovation, and raised the issue that that's pretty fuzzy. And how do you, how does the CFTC effectively balance its obligations on supervision, regulation, and enforcement, and kind of responsible innovation?
Well, fundamentally, the words, the purpose of responsible innovation is sort of in the purpose section of the Act. So it's something that this is one reason why we're setting up this regulatory system, but the regulations apply to technology, whatever it is. There's no, both the commodities laws and the securities laws are technology neutral. Nobody gets a break because they've got some way of doing it. It's on a blockchain or it's not on a blockchain or whatever. You've got to follow the law, and both statutes have, both the securities laws and the commodities laws have the consideration of costs and benefits in making a decision. So both agencies go through extensive analyses of costs and benefits, and it's something that is considered. But an innovative technology doesn't get more or less of a legal break than a non-innovative technology.
Okay, great. I'm going to jump to you, Hillary, but before I do, I just want to say we at Better Markets have been in the forefront of arguing against cost-benefit analysis in a quantitative way at the SEC in particular, which has only a statutory duty to do consider specified economic analysis. And for anybody who's interested in that in the audience, we have a substantial amount of information on our website, bettermarkets.org, about the appropriate standard to use, the downside of quantitative cost-benefit analysis, which we call industry cost-only analysis, for the obvious reasons. But let me get back to you, Hillary. The question that Dan started with a bit ago when I asked it had to do with crypto's promises to marginalized and underserved communities.
Yeah, I mean, I think you have to be really careful of this kind of rhetoric. I mean, this rhetoric reminds me of the rhetoric around subprime mortgages in the lead up to 2008, right? A lot of sort of inclusion or things that are nominally financially inclusive end up being predatory inclusion. And that's, I think, a particular risk when you're looking at crypto, because ultimately there's no assets backing a crypto asset, right? What you're purchasing is a computer file that's value depends on whether someone else wants to buy it from you. And I should say this is a separate and apart from the stablecoin analysis, but for most tokens, the value depends on whether someone else is willing to buy it from you, no more, no less. So for crypto tokens like that to continue having a value, then you need to find another buyer. And so there is a real concern that, the more vulnerable communities are being targeted as potential bag holders to allow the more affluent people who got in earlier to exit. And so I think that's something that we need to be very careful of. It sort of casts a bit of a pall over claims that, look, recently we've had, this many Black or Hispanic or LGBT or young investors pile into crypto. Maybe they're the bag holders.
It reminds me when I was reading the Ripple decision, which, talked about a lot of different things. If I'm remembering right, the judge also mentioned in passing, as he talked about the CEOs, that the first CEO cashed out something like $480 million. And the second CEO cashed out something like $140 or $180 million. And I'm just wondering how many people in the marginalized communities they pretend to be enriching took any fraction of that amount of money in the period of time they did. There seems to be a rather vast discrepancy between the amount of money the insiders are pocketing, which is literally hundreds and hundreds and hundreds of millions of dollars, versus what the underserved communities or even just regular retail investors are finding. I wanted to turn before we run out of time to the legislation. Before I did that, Hillary, you mentioned that often the value of a token depends upon what the next person will pay for it. And I was trying to figure out, how do you distinguish that from a Ponzi scheme as a law professor?
I mean, I think I've definitely described crypto as Ponzi-like. I think, the question, with a Ponzi scheme, there's generally one person pulling the strings. Maybe that's, I'm not sure if you can say there's one single person pulling the strings over the entire industry, but it's definitely Ponzi-like.
It seems to be, you're true. It's not just Bernie Madoff trying to get away with it. It's a whole bunch of little Bernie Madoffs. It's almost like a Ponzi scheme business model as opposed to a Ponzi scheme. It really seems like it's been turned into the Ponzi has been turned into an actual business model that has been followed by lots and lots of people. I wanted to, before I get to the legislation, I wanted to ask Dan a quick question. Because you've had the benefit or detriment, I guess, of working at the CFTC and the SEC, in seeing the vast number of mandates that come your way as a regulator. And our view at Better Markets has been that, unfortunately, the CFTC and the SEC have been grossly underfunded for years and have difficulty, frankly, in our view, discharging and satisfying all of their current statutory mandates. And I was wondering what you would think would happen if anyone, regardless of content, any one of the crypto bills that are being circulated and talked about get enacted without substantial additional financial resources in the hundreds of millions of dollars to the CFTC and the SEC. Is there any way either agency could possibly satisfy those mandates under current funding?
Well, with substantial additional mandates, you would need substantial additional funding, particularly if any substantial new regulatory authority for exchanges, for instruments, for asset classes, for self-regulatory organizations and rulemakings would go to the CFTC. The CFTC has just been on the shoestring for years. I don't think they're even funded at the level that the agency has requested for a while. And substantial new responsibilities would really cut into either they couldn't do the new responsibilities or it would be to the detriment of their existing responsibilities. One of the strengths, why do we even have the CFTC? There have been proposals over the years to fold it into the SEC, but the CFTC, because its roots are in the agricultural markets, its roots are in the commodity markets, and it requires a specific expertise that it can focus on the commodity markets, the commodity futures markets, and now the swaps markets, augmented by the National Futures Association, which plays a significant role in overseeing the swaps markets now. But that focus on the commodity markets and its importance to our economy has really kept the CFTC separate from the SEC and separate from being swallowed up. If you turn the CFTC into a major crypto agency without significant additional funding, then again, that critical role and focus of the CFTC, you're at serious risk of losing. I won't say it publicly in terms of the enforcement resources, but the CFTC, and this is an area where we're seeing a lot of enforcement. It's the CFTC, while I was there, is just very, very stretched on enforcement resources and expanding its authority and expanding what it's going to be enforcing on. You would really need a significant increase in funding to accomplish that.
Yeah. Okay. I mean, I think that should be obvious, but it seems it's not very obvious to many people who claim to be smart in Washington, D.C. It just is astonishing to me that they cavalierly talk about, frankly, transforming agencies into being crypto light touch agencies and not giving them hardly any more money to discharge that when at least the CFTC has been chronically underfunded, frankly, in my view, as a conscious strategy of the financial industry to ensure that they can't do their job, and to ask them to do more, to not do their job even more strikes me as the worst fraud on the public you can get. But I want to turn to, in the last 5 minutes or so, there are several proposals on the Hill to regulate crypto. There's all sorts of claims as to why this regulation is needed. One question from the audience, says the crypto lobby and its congressional backers claim that U.S. regulation of crypto will drive crypto trading offshore. Has the claim been persuasive in Congress? Is there anything proposed in the McHenry-Thompson bill to prevent cross-border regulatory evasion? So we have, McHenry-Thompson in the House. We have an old version of Stabenow-Boozman in the Senate that they've been saying they're going to come out with version 2.0 since the beginning of the year. That was the bill that was embraced wholeheartedly by FTX and its now arrested CEO, Sam Bankman-Fried, who not only supported it, there were some reports that they virtually wrote it. And then we have the Lummis-Gillibrand bill, which was filed last year and was just refiled, I want to say Thursday or Friday, 258 pages. There's some overlap in those bills, all of which are quite crypto friendly, to say the least, if not crypto obsequious. So I don't know where you want to pick up. I'd like to get your thoughts, starting with you, Hillary, on kind of legislative proposals.
Sure. Well, I'm going to leave the SEC versus CFTC divide to Dan to talk about because we're short on time. So I'm just going to sort of raise a couple of dot points, which I think are really problematic about these bills. And I'm speaking sort of about them collectively, even though there are variations in the provisions. So one is something I already alluded to, which is that in many ways they unintentionally or perhaps intentionally eviscerate the existing securities laws for non-crypto securities. There's nothing particularly special about a digital asset, right? So you could convert almost any financial asset, put it into a computer file and put it on a blockchain, right? And then they would be able to take advantage of the new legislative regime. So I think policymakers need to be aware that any new regime they set up will not just be a regime for crypto, but it will attract, if it's lighter touch, all kinds of other financial assets. And that's something that has not been adequately acknowledged or prepared for. And I don't think there's any avoiding this, I should say, because digital asset can't be defined in a way to exclude traditional assets.
So Hillary, if I understand you right, what you're really saying is if you're going to provide a lighter touch or different regulatory regime for crypto, do not fool yourself into thinking it will only apply to some little subset called crypto, because with regulatory arbitrage, it will be a loophole that will get expanded to cover lots and lots of other stuff and cause lots and lots of other collateral problems. Have I got that right?
Yeah, that's right. Another big picture concern is that if you pass this kind of legislation, it will inevitably legitimize crypto as an asset class for institutional investors to invest in. I mentioned, bag holders. This, as I said, because this is Ponzi-like, there's a desperate need for new money. And that new money can only come at this point. I mean, so I think Pew recently came out with a survey that said 75% of Americans who've heard of crypto aren't confident in its safety and reliability. So, the consumers are wise to this. And yet, the industry is still trying to make crypto happen. And so what they're trying to do is create legislation that will allow institutional investors to invest. And that's a problem from a financial stability perspective. That means when crypto blows up, it doesn't just hurt crypto and individual investors, it hurts banks, pension funds, et cetera. And we need to be very aware of that. Another big picture item is a lot of the legislation around stablecoins proposes bringing it into the regulated banking system in some way, shape, or form. So you're essentially giving government backing to stablecoins, and stablecoins are not used for payments. They're used primarily for speculation in crypto. So essentially, you're putting government safety nets behind crypto speculation. So that's something to be very aware of as well. I could keep going, but I'm short on time, and those are my top.
We could probably talk for hours about this and many other things. So Dan, we're going to run over a little bit. Why don't you give us and the people who are watching need to drop off, they can, but give us your thoughts on kind of the
much aligned with what Hillary just said. Earlier we talked about Howie and how it's a functional test. You look at the function, and even if you look at Judge Torres's opinion from in the Ripple case, she really emphasized the economic reality. What is the function now? How she applied it, one can say, one can discuss whether she got it right or not, but she still focused on the economic reality as she saw it of the transaction. And that's what Howie stands for. The legislation moving from the economic reality of the transaction, are you trying to raise capital, you're taking money from others, to a technology base, like how is it structured on the blockchain? Is it digitized versus some other representation? Inevitably will enable these capital raising functions to be carried out in a technologically different way. You have a bifurcated system, which I think raises all sorts of problematic possibilities in terms of raising capital and doing these exact same things that are now regulated under securities laws and taking them out of the securities laws when they're really securities, have been securities type transactions for so many years. I think you can provide, if you look at my testimony, I won't summarize, I think you can provide the certainty that you need, close the regulatory gap and provide the regulatory certainty you need without changing the underlying nature of what is a security or not. You can provide the SEC to declare upfront on whether these are securities or not, rather than solely on retrospective enforcement actions as now the case. And you can construct a system to do that, enable the SEC to do its job, enable the CFTC to do its job, and give the industry the regulatory certainty they need on the nature of these assets without undermining securities laws. So I think it can be done. I'm wary of changing the nature of what's a security, though, to get there.
It sounds to me like it would take an extraordinary level of faith that Congress would get it done with the nuance that you just described. And of course, I assume, Dan, that you share Hillary's concern that the problem with almost any legislation is legitimization for the industry itself when it remains at its core Ponzi-like, unless it really becomes, unless they all decide that they're going to start complying with the law, eliminate the conflicts of interest, segregate the business activities, et cetera.
Well, you set up a robust regulatory system for the markets that are currently not regulated. You close the gap, you close the regulatory gap in a robust way. I mean, that can be done. I mean, I actually have faith, even after all these years, Dennis, I actually have faith in the system. I actually have faith that it can happen and that we can get good legislation, but it takes work.
Well, good to see that after all these years, you've got some faith. You must not be paying much attention lately, however. Well, look, thank you very much, Dan and Hillary. There's not two better people who know more about these subjects and are independent and fearless, and we appreciate that. For the audience, you should know we are going to post, some of it's already posted on our website. We'll post some more. All sorts of resources to answer questions, from stable coins to the pending legislation to the SEC's enforcement record, you name it. And we'll also be sending out an email with resources that include Dan, Hillary's testimony, and some other things like the book. What was that, the subliminal thing they did in the 50s, you know? And Hillary also, I think, has some additional papers coming out and writings coming out soon. So follow her when you can, because she's a tremendous resource. And Dan, we're trying to get him to get more active and more vocal and raise his public profile so more people get the benefit of his expertise more often, rather than having to wait for a Better Markets webinar. But that doesn't mean don't miss any Better Markets webinar. But thank you all. We appreciate you all attending. And Hillary and Dan, thank you very much.
Thank you.